Good afternoon, everyone. It's the top of the hour, so we're going to go ahead and get started so our speaker has as much time as possible. I'm Jenna Kirsten, a member of the marketing team here at Kirkpatrick Price, and your host for today's webinar. I'd like to thank everyone for joining and taking time out of your busy day for our session on GDPR. We're going to discuss how the law defines personal data. We know there's tons of GDPR resources out there, so thank you for joining us today. Let's go over just a few things before we dive into our discussion. All attendees will be muted throughout the session, but we do encourage you to ask questions using the Q&A feature, which is located in the WebEx toolbar. I'll monitor those throughout the hour and have some time reserved at the end to answer those. This session is also being recorded, and everyone will receive a link to the recording as well as a copy of the slides in your inbox tomorrow. Just a little bit of background about us before we get started. Kirkpatrick Price is a licensed CPA firm providing assurance services to clients worldwide. Our firm has over 13 years of experience in information assurance by performing assessments, audits, and tests that strengthen information security and compliance controls. We offer both regulatory compliance and information security services. We provide consulting services such as policy and procedure drafting, risk assessment, internal audit plan and development, and readiness audits. We also provide guidance and audit services on frameworks such as SOC 1, 2, SOC for cybersecurity, PCI, HIPAA, HITRUST, FISMA, ISO, and of course GDPR. We also encourage you to connect with us by subscribing to our blog, visiting our library of on-demand webinars, and following us on LinkedIn, Twitter, or Facebook. Our speaker for today is Mark Heinley, a regulatory compliance specialist here at Kirkpatrick Price. If you've joined us for our other GDPR webinars, you already know that Mark is an expert in privacy law from his 10 years of experience in private practice, regulatory affairs, and internal regulatory compliance. We are lucky to have him today. Welcome, Mark.
Thank you very much, Jenna, and thank you to all of you for joining us in today's webinar. As Jenna noted, we're going to be talking about what constitutes personal data, who that covers, and what kind of data that covers. Before we get into our content, I want to provide a legal disclaimer, particularly for today's webinar. This presentation is provided by Kirkpatrick Price for educational and/or informational purposes only and does not constitute legal advice. No attorney-client relationship is established by viewing this presentation. Should you need legal advice, please consult with your own attorney. Now that we've gotten our disclaimer out of the way, we can get into the content for today's presentation. We're going to talk about what is personal data under GDPR, who, what, and why. Like any good journalistic effort, we're going to ask and answer those questions. Before we get into each of those three questions, I wanted to give a brief GDPR overview just to ensure that we're all on the same page before we address the specific elements of the law. First, GDPR is a European data protection regulation that grants rights to data subjects. It requires organizations to process data with certain principles, including the principles of lawfulness, fairness, transparency, and security. And it asserts international jurisdiction over EU data wherever that data is located or processed. And it is enforced with severe financial penalties, and enforcement begins this month on May 25th. So the law is already in effect, but it will be enforced at the end of this month. So now that we've done a brief overview, let's talk about the why. So why are we talking about personal data? From my perspective, especially for non-EU-based organizations, the question of what personal data is covered by the law is the most important question that any organization can ask. It's basically asking the question, does GDPR apply to our organization at all? It's also one of the most frequent questions that we get when we're in GDPR engagements, is to identify which data applies, to what extent that data applies, and to provide organizations with a sense of not only is the organization subject to GDPR, but how broad is that regulation apply to their organization. And then third, interpretations vary about what personal data is covered by the law. Not only do interpretations about who is a data subject vary, but interpretations about what constitutes personal data elements vary. So if you've looked for a clear and defined answer and come away frustrated and perhaps more confused than when you started, you're not alone. My goal is to not establish myself or Kirkpatrick Price as the arbiter of what constitutes personal data, but to identify some of the issues and some of the language in the law that I think will give us at least some good principles to use when we're identifying what constitutes personal data, and to be aware, just to be aware of the fact that there is confusion among reasonable people and practitioners. And then the challenges are significant. Depending on the interpretation an organization takes regarding who is the data subject and what data is covered, the impacts on their organization could be tremendous in the amount of controls and security and responsibility and risk that each piece of data covers, how that data is shared, how that data is used, and how that organization interacts with data subjects. So while we're going to talk about some technical legal aspects, this is an incredibly practical and impactful topic to make a decision on. So my goal for today's session is to answer the questions, about who is a data subject, and to try to provide some guidance on this. So let's talk about the who. The law, GDPR itself does not define the term data subject. It uses that term within other definitions when it's defining the concept of personal data, but it doesn't actually define the subject. It does refer to data subjects as identified or identifiable natural persons, and then it provides limited, confusing parameters around what a data subject is. So let's look at some specific aspects of the law to help us get some principles that we can try to use to make a decision about what our organizations believe constitutes a data subject. First, Article 3 says that GDPR applies to the processing of personal data of data subjects who are in the union, and that italicized language is my own emphasis. This is an aspect where I think the confusion already starts, is the location of, to some extent, what in the union means, whether that actually is physical location or some kind of residency or citizenship. And then in Recital 2, we have a statement that says the principles of and rules on the protection of natural persons with regard to processing their personal data should, whatever their nationality or residence, respect their fundamental rights and freedoms, in particular their right to the protection of their personal data. So Article 3 says that GDPR applies to data subjects who are in the union, but then Recital 2 says that the principles of data protection apply whatever an individual's nationality is or their residence. So, again, we have a second layer of confusion. Does whatever their nationality or residence mean that it doesn't matter whether they are formally residents of a member state of the EU or where they are living at the moment? Those are kind of questions. And then if it doesn't matter where they reside, how does that work with the statement in Article 3 that says the processing of personal data, that GDPR applies to the processing of personal data for data subjects who are in the union? So right away we have two different principles. One, the first in Article 3 saying that the law applies to those data subjects who are in the union, and then Recital 2 saying residence is irrelevant for data protection purposes. Just to make things a little bit more confusing, let's go to Recital 14 and get some more guidance. It says the protection afforded by this regulation should apply to natural persons whatever their nationality or place of residence in relation to the processing of their personal data. So here we have a modification of the term residence. Now it's a place of residence, which could indicate that it doesn't matter where they're located physically at the time of processing or where they're living physically at the time of their processing, that GDPR would still apply. And then finally, Recital 24 says the processing of personal data of data subjects who are in the union by a controller or processor not established in the union should also be subject to this regulation. When it is related to the monitoring of the behavior of such data subjects insofar as their behavior takes place within the union. So this seems to collaborate and support the statement in Article 3 about location being important. So we've got 4 different statements within the law itself, 1 in an article and 3 in recitals, in addition to many other statements that are made in the law that don't uniformly establish who is a data subject. But we can get a couple of principles from those 4 different statements. First, data subjects are identified or identifiable natural persons. So we're talking about individuals, not corporations, and we're talking about individuals who you can identify. That means anonymous data, as we'll talk about at the end, is not subject to GDPR. It says that data subjects are in the union. To the extent what that means is still unclear, but there must be some connection to the union. Then data subjects are data subjects whatever their nationality or place of residence. And then 4th, data subjects are data subjects as far as their behavior takes place within the union. So as I indicated, these 4 principles aren't necessarily coherent. So you've got several different possible issues that come out of these principles from specific statements in the laws. First, you have no formal definition. You have apparently inconsistent terms. You have no formal guidance from the Article 29 Working Party. And then you have some dated supervisory authority guidance, especially from the ICO from 2012 that we'll reference briefly, that makes things even more confusing. So this is the reason that we're talking about this in today's session, is because within the law, the terms are confusing and potentially inconsistent, and outside of the law, both from Article 29 Working Party and supervisory authority, we don't have enough guidance to make a clear uniform decision. So let's talk about some of the different interpretations that are floating out there in webinars and blogs and opinion memos on this issue. One possible interpretation is that data subjects are located in the union. So that is, a data subject is anyone who is physically within the borders of the European Union whose data is being processed while that individual is physically within the union. And that interpretation comes from the first and the last of the 2 statements in the law, that it applies, GDPR applies to those who are in the union and those whose behavior is monitored within the union. A second interpretation is a resident who is in the union. So this is slightly more narrow. A data subject is anyone who formally resides within the union, regardless of citizenship, while that individual is physically within the union. So you still have the concept that the person has to be in the union while their data is being processed, but now you've added the concept of residency, whatever that legally means. And the difference between the first and second definitions would be that the second definition would exclude the data of a tourist or someone temporarily located or residing in the EU. So the first definition captures anybody who's physically present within the EU, both EU residents and citizens and non-EU residents and citizens whose data is being processed while that individual is physically there. The second narrows it down, still has the physical location element, but moves from just anyone to residents. Then getting even more precise and specific, you have the interpretation that it's a data subject is a citizen who has formal citizenship in a member state of the EU while that individual is physically within the union. And this takes the first 2 interpretations and makes it even more particular, because there are defined concepts and ways, tangible ways to identify whether someone is a citizen of a member state in the EU. So it's more clear, but not necessarily more accurate. And I'll talk about that after we talk about our 4th interpretation. So the 4th interpretation is that a data subject is a resident or citizen of the EU or member state of the EU wherever they reside. So anywhere in the world, wherever, for example, a French citizen is wherever they are, wherever their personal data is being processed, the GDPR applies to that data. So one of the things that I have noticed is a frequent use in content, in unofficial GDPR content, and the use of the term citizen. That GDPR applies to EU citizens. And just should be important to note that the word citizen is not used in reference to data subjects or personal data. So I'm reluctant to use citizenship as a standard for identifying who a data subject is. It's not impossible that that's an interpretation, but just note that when we talk about the concepts of GDPR, it's most accurate to use the word EU data subject as far as, or term EU data subject as far as I can tell, rather than EU citizen. The fifth interpretation is that it's a personal data, a data subject is anyone whose data is located in the EU, regardless of the residence, citizenship, or physical location of the data subject. So you could have, for example, a Brazilian citizen whose data is being processed in the EU, even if that Brazilian citizen is not physically located in a member state in the EU at the time of processing. This is potentially an incredibly broad understanding of the law and extends jurisdiction. Not only, jurisdiction is already asserted that it's international, but this asserts not only international jurisdiction, but jurisdiction over all, anybody can be a data subject. It's just the location of the processing. I think there are problems with this interpretation. If someone is not located in the EU or some aspect of their behavior is not in the EU, then I'm not sure how that interpretation meshes with the final recital that we mentioned. I also think that there are challenges with other nations' data protection laws being compromised or in conflict with GDPR by interpreting the data subject as anyone whose data is located in the EU. For example, a data center in the EU might store the personal data of individuals from around the world. I think it would be impossible for that organization to comply with all of those laws. And not only that, but there might be inconsistency between GDPR and the laws of a nation where the individual resides or has citizenship. But these are the possible at least 5 possible interpretations of a data subject. So whatever the answer is, here are a couple of issues to consider when you're making a decision. And then I'll give you towards the end some personal opinions on this. Formal citizenship and residency requires are some of the considerations. Location of the person when the data is being processed is a consideration, and location of the data is a consideration. So here are a couple of examples to flesh out the potential interpretations of who is a data subject. So, and to move from most clear to potentially less clear. A citizen of the EU, physically located in the EU, purchases a product, and in doing so, when they make that purchase, they provide personal information. From my perspective, that is the easiest, most clear example of who is a data subject. Then you move to a situation where a non-EU citizen who is physically located in the EU, purchases a product, and in so doing, provides personal data. In that case, you could have, for example, a couple different options that make this particularly challenging. You could have a Canadian citizen who's on vacation in the EU purchasing a product and providing personal information. If you take the interpretation that it's the data, not the residency, citizenship of the individual, then that Canadian citizen's personal data is subject to GDPR. Or if you have a South African citizen who's residing in the EU on a permanent basis, who purchases a product and in doing so provides personal information, is that subject to GDPR? They are located physically in the EU when the data is processed, they're actually residing in the EU. So in that case, I think it's a stronger case that GDPR applies than perhaps someone who's simply on vacation, but still not perfectly clear. And then the third example would be an EU citizen, and this is the more difficult, challenging scenario, I think, is an EU citizen located, for example, in the US or anywhere outside of the EU, purchases a product, and in doing so provides personal information. And this is the case that is going to be a challenge for most organizations, is to decide whether or not this individual is a data subject at the time of their purchase and the time of providing personal information. Article 23 references the provisions of goods and services to data subjects who are in the union. That's in addition to the language that we already read. So from my perspective, I think there is a reason to believe that the data subject's location matters, and if they are not located in the union, there's and their behavior is not taking place in the union, there's a potential that they are not a data subject, and that their data is not subject to GDPR. But from a practical perspective, do I think that the EU is likely to consider that data subject to GDPR? I think the answer is yes. Whether that's what the law should actually be interpreted as or not, I think that there's a desire to ensure that the rights and protections established under GDPR extend as broadly as they reasonably can. So, so you have this dynamic where you're reading the law based on the language of the law, and then you're considering the practical implications and how the law actually might be interpreted. So here you move from what I think is the most clear example of someone being a data subject, that's a citizen of the EU, physically located in the EU, providing personal information for the purchase of a good, to the situation that is most difficult, a EU citizen in another country purchasing a product where their behavior is outside of the EU, the processing is outside of the EU, and whether or not that individual is a data subject and the law applies. So let's wrap up this portion of our presentation, and I'll give you some personal thoughts. First, if it wasn't clear enough from our presentation, it should be clear now that the law is not clear, at least from my perspective. The four different sections of the law that we read, plus Article 23 that I read there at the end, to me are not consistent. Second, reasonable people who have credibility and intelligence disagree. I've seen individuals take each of those different interpretations that I referenced, and there's perhaps a few more, and make defensible positions for each one of those. So this is not an easy decision to make. Finally, some of my personal thoughts. Data subject location is important. I think the language in the union and behavior in the union matters, and I think it has impact on my own perspective on who is a data subject. But I also acknowledge that practical realities impact compliance. And if you're taking a conservative approach, I think the perspective that a data subject is someone with a connection to the EU, and they're providing personal data regardless of whether they are in the EU or not at the time that they provide that data, that's to me seems the most reasonable and supportable position. But as I said, the law isn't clear and reasonable people disagree. So, just as a way of wrapping that up, just want to give some examples of why practical realities might make this a challenge before we talk about the personal data points. I wanted to just get specific with why this is so difficult. You could have, for example, an American utility company providing services in the United States to a residence owned by an EU citizen, and it's problematic interpreting GDPR to apply to that transaction based on the language of the law that says it applies to organizations that envision offering services to data subjects in the EU. Other examples could be EU citizens or residents obtaining healthcare services in another country. There are situations where it's not practical and may even be impermissible for an organization to ask for or attempt to identify the nationality of an individual that it's providing services to. So if you are legally prohibited from identifying the nationality of someone you're providing services to, and they happen to be from the EU, either a resident or a citizen, and you obtain their personal data, but you don't know in that transaction that they do have a connection to the union and they're not in the union, you may be subject to GDPR. If that's what the law covers, then you may be subject to GDPR without even knowing it. And it's one thing for a utility company or a large healthcare provider, a hospital or a hospital system, to be able to have the resources to comply with GDPR. It's a much more unrealistic thing to expect small retail providers and small individual proprietors providing services to be able to comply with GDPR. Now, even if they are technically subject to GDPR based on the interpretation of the supervisory authority, are they likely to be sanctioned for noncompliance? It's probably unlikely, but the position that they're in is already difficult. And in fact, just yesterday, a not small provider, the email management service UnrollMe, published their decision to stop services in the EU because they stated that GDPR compliance was not practical or reasonable. And so they're just going to provide services to, I think at this point, individuals in the US. So that just demonstrates the practical implications of deciding this. Even UnrollMe, though, in taking that position that they're not going to provide services, has to make a decision about who is a data subject. They said they were going to go ahead and delete all the users that they believed were subject to GDPR. In doing that, they have to make a decision about who is a data subject in order to sort of carve themselves out of GDPR jurisdiction. So even if an organization says we don't want to be subject to GDPR, therefore we're going to take this step, they still have to answer the question that we just spent about half an hour talking through and face all the challenges there. So this is really a question that applies to everyone, even if it's an organization that's thinking about limiting their GDPR risk and exposure. Practically speaking, for some organizations, parsing between citizens and residents and tourists and temporary residents is an incredibly challenging decision-making process, and it may not be practically realistic or useful. So it may be that it's more effective and from a cost and resource perspective and risk exposure perspective to take the most conservative position and make GDPR applicability broad and say just about everybody is a data subject. And it may be that the test becomes sort of one of awareness. The more likely an organization is, especially an organization outside the EU, is that it's processing data of someone with a connection to the EU, the more likely they may be to subject to GDPR based on that knowledge. That's not something specifically from the law. That's me trying to use my perspective and try to craft something that can be useful in applying this difficult topic. So now that we've addressed the challenge without necessarily coming to a firm conclusion about who may be a data subject with all those different possibilities, even if you came to a firm conclusion about that, you'd still have an additional question to ask in talking about whether or not GDPR applies and to what extent GDPR applies, because we need to ask the question about what data are we talking about. And for our purposes of discussion today, there are three parts to this answer. There's what I'm calling the logical part of the discussion, and that's data that constitutes personal data because that data can be used to identify a person. There's the legal portion of it, and that is the law intends for GDPR requirements to apply to certain data that can identify a person, and there may be some, based on guidance from Article 29 Working Party, there may be some data that would be technically subject to GDPR, but the law does not intend for GDPR to apply to. And then there is, as I mentioned at the beginning, identifiable data, because GDPR does not apply to anonymous data. Now, when I say logical data, that concept is a term that I'm using just for clarity purposes to distinguish between sort of the legal aspect, but it is an element of the law. So I want to make sure that that's clear, because that's what we're going to talk about first, is this sort of logical aspect of what data elements we're talking about. Article 4.1, this is in the definition section, says that personal data means any information relating to an identified or identifiable natural person that is a data subject. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, or an online identifier of one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. So we get some specific examples of, we get a concept of what data elements we're talking about and some specific examples in terms of name, identification number, location data, and then sort of these identifiers that cross a spectrum of different concepts. From my perspective, this definition this definition gives us examples that are similar to or identical to other legal definitions of personal data in data protection and data security laws around the world. So this concept of personal data should be less difficult to understand and implement. But GDPR doesn't just leave us there. It gives us some additional concepts that may be more difficult to talk about. So, and the next section of the law is from Recital 30, and it says, natural persons may be associated with online identifiers provided by their devices, applications, tools, and protocols, such as internet protocol addresses, cookie identifiers, or other identifiers such as radio frequency identification tags. This may leave traces which, in particular, when combined with unique identifiers and other information received by the servers, may be used to create profiles of natural persons and identify them. So this part of GDPR broadens the traditional concepts of personally identifiable information beyond many existing legal definitions of PII to address the way people today use the Internet of Things, the way that organizations use the data that comes from devices, applications, and tools, and the general lack of transparency regarding this data tracking and use. And if anything, the circumstances around Facebook and the Cambridge Analytica circumstance reinforces this notion. While those that's not from that information wasn't obtained from devices, that reflects the lack of transparency that at least is perceived, if not as an actuality, that organizations use data and transfer data. And so we get some additional specific elements of personal data when we're talking about IP addresses, cookies, radio frequency tags, MACs, and other things, other items that, you know, as the language uses, leaves traces and creates unique identifiers that can be connected to identify individuals. So this portion of the logical aspect of what data elements we're talking about is anything that you can connect to identify an individual with, the sort of traditional items and then the more technological items. Here are a couple of additional examples of data that can identify a natural person. You have physical address, email address, phone number, photograph, video, voice recording, and then biometric data such as eye retinas or irises, fingerprints, and then even unique facial identifiers. And so these are all, you have now a full spectrum, I think, of sort of nitty-gritty specific elements that you can think about for your organization about whether or not you capture or receive or process in some capacity these different data elements. But there are some challenges when we're talking about this sort of logical portion of what constitutes data that is subject to GDPR. First is this concept of indirect identification, and then second is personal data that isn't personal data. So let's first talk about this first challenge of indirect identification. So the language of GDPR and the definition from Article 4 says, uses the term directly and indirectly to identify someone. So you've got cases in which context is going to matter significantly. For direct identification, that's fairly easy to understand, if not to implement. Direct identification comes from items such as genetic data, certain identification numbers, or things like a photograph. Those are ways in which you're directly able to identify a person without necessarily having another piece of information or requiring another piece of information to identify that individual. But in terms of indirect identification, you have a situation where a single element might be personal data in some contexts, but it might not be personal data subject to GDPR in other contexts. Let me give you an example. So let's say that an organization has job titles that are common to manufacturing of goods. So this organization, it's either an organization that sells machines to manufacture goods, or it's a trade organization that is related to manufacturing services. So just having common job titles for manufacturing, such as manager, director, engineer, something like that, may not be a piece of personal data at all. That might not be, you might not be able to identify a person even indirectly with that item. But then if you added to that a list of the most common purchases of manufacturing equipment by job title, so a director of engineering in this area might, with this additional title, this is the kind of good to manufacture other products. That's the most common, the number one good that they purchase. So now you have two pieces of information that have narrowed the pool of candidates down a little bit, but even together they might not be personal data. But then if you added the location data for the most common purchases, well, then you might only have a single individual who is the director of engineering who purchased that kind of manufacturing equipment. So what happens is the location data on its own might not give you, might not constitute personal data, but when it combined with those other two elements, you have items that on their own, as I said, might not constitute personal data, but in collection, they might allow you to indirectly identify an individual. So one of the challenges is not just establishing what data elements your organization collects, but how they might be used in conjunction with one another to identify individuals. So you might have pieces of data in your organization that you think on their own are not personal data, but then someone within your organization might have access to 2 or 3 of those pieces separately. And when they have access to that, they now have the ability to identify someone. Or you might transfer data to a processor or to another sub-processor, and in the same capacity, separate that data, and in doing so think that the data isn't personal data because it's not able to identify an individual. But when that data is combined, you might create a situation where GDPR now applies. So one of the challenges when you're thinking through what constitutes personal data, it's not just knowing a list of elements, it's considering what you can do with those elements once you have those elements together. The second challenge is that personal data isn't always personal data. So the UK Information Commissioner's Office has set in guidance that was published prior to the implementation of GDPR that even the name of an individual may not make an individual specifically identifiable. I want to note that this guidance was called Determining What is Personal Data and was based on the Data Protection Act, and I think it was dated from 2012. But I think it's informative even if it's not applicable. And basically the idea was that a common name doesn't necessarily narrow down from a group of individuals to a specific individuals, but that a common name in connection with other pieces of information, to go back to our indirect identification situation, would then transform that name into a personal data element. So if you had that name, a very common name that in a country, with millions of individuals, if 500,000 people had that same name, is it possible that that's not personal data just on its own because there are so many people that have that name? It seems from that guidance from 2012 that that's possible. But then if that name is combined with an address, a physical address or an email address, or that name is combined with an employer, or that name is combined with a telephone number, then you might have narrowed down and created an opportunity for indirect identification. So if things weren't confusing enough and that you can't just know which elements are personal data, it's to know that an element, a name, which is specifically called out in Article 4 as an item of personal data, may not actually be personal data if it's not, potentially, if the name is so common or what the other data element is so common that it doesn't help you narrow down the pool. I would be conservative in supporting that approach, that if somehow your organization only had a name that it didn't constitute personal data. And from my experience, very, very unlikely for an organization to just have a name without some other connecting piece of information, but that principle at least is out there for your consideration. So here are some principles for identifying personal data from a logical perspective. It does depend on the data element. It also depends on the context, to consider what other data elements are connected. Recital 30 says, uses the term when combined with other identifiers. And while that's specifically referring to devices and IP addresses and certain electronic signals, I would also apply that language when combined with other identifiers to all elements of personal data. So not only do you have to think through something, can it be used to identify an individual, but can it be used in conjunction with other pieces of information to identify an individual? And then there's a final element that we haven't talked about yet, and that is the reasonable likelihood of identification. And this is an idea that comes from Recital 26 that basically says when you're thinking about whether a natural person is identifiable, you should take into account the means likely to be used and whether or not it's reasonable considering objective factors that someone could be identified. So specifically, objective factors are cost, the amount of time required for identification, and available technology. So if it was theoretically possible for someone to identify an individual based on a particular piece of information, but it would take them 20 years, millions and millions and millions of dollars, and technology that is not yet commercially available, then you might be able to say, well, then this piece of information might not be personal data. But if you could say it would take someone about 10 minutes with a device and technology that's available to almost everyone, such as a smartphone, and it would cost no money to identify that individual, then you're more likely to have personal data from a logical perspective. All right, let's talk about personal data elements from the legal perspective. And what I mean by that is that there can be cases where data may identify a person, but may be excluded from personal data as a matter of law. And I take this position and share this with you based on the guidelines on the right to data portability, last revised on April 5th, 2017, and this is an Article 29 Data Protection Working Party guidance. And it says that personal data can include multiple different, not just data elements, but sources of data. One of those, it seems obvious, is personal data provided actively and knowingly by the data subject. So when an individual gives a retailer their name and their email address, that's a case where you've got data that's provided actively and knowingly by a data subject. But personal data could also include what's called observable data provided by the data subject by virtue of use of a service or a device. And the guidance gives examples of webmail directory of the data subject's contacts and history of music liked on a streaming music service. So those aren't pieces of information necessarily given to the controller or the processor, but they're pieces of information that come about when someone is using a streaming music service. Those seem to be obvious. Those are personal data. The guidance says it. But then you have this other statement from the guidance that makes things a little bit more challenging. It says that you should interpret the language provided by the data subject broadly, and at the same time, you should exclude what's called inferred data or derived data. So examples of data that could be considered either inferred data or derived data are the outcome of a health assessment. So this is a situation where an individual may provide their name, their age, their weight, their blood type, their cholesterol, their blood pressure, and an entity collects all of that information, makes an evaluation of those factors, and creates a health assessment based on that information. From my perspective, that outcome would be, that health assessment would be information that could be used very easily to identify a person. But the law seems to say, based on this guidance from Article 29 Working Party, is that's inferred or derived data, and it's not subject to a data portability request. Another example it gave was a similar situation, only instead of health, it was like a credit or financial or risk profile about an individual. So someone's applying for some sort of credit, whether it's a credit card or a loan, and they provide pieces of personal information that are explicitly personal data, and an entity like a bank creates a financial profile that could be used to identify the individual, but this guidance from Article 29 Working Party says that's inferred data and derived data. So this creates an interesting scenario for us to think through. If this guidance is, to the extent it's useful across the board for understanding what constitutes personal data, then we need to differentiate between data that is created by a data controller on the basis of data provided by the data subject, and data that's provided by the data subject. So think through scenarios where your organization is creating data using personal data, and what your organization creates could be used to track the information back to a specific individual. You have to decide whether or not what you've created is derived or inferred data, or whether that data is something that was provided by the data subject, whether directly or through use of a service, to determine whether or not you have personal data. Now, I want to give a qualifier to this concept. These conclusions about what constitutes personal data from sort of a legal excluded by law perspective, as I said, are derived from the guidance on data portability. There's a potential that someone could say, well, that only applies to responding to a request for data about what data you should give them. But I think there's a good argument to be made that this guidance helps us not only with respect to that right, but also with respect to identifying what is personal data for issues like breach and consent and data protection impact assessments and any other aspect of GDPR compliance. So we'll talk about one more item with respect to what data elements we're talking about, and then we'll move to our conclusion. As I mentioned at the very beginning, to be subject to GDPR, data elements must be identifiable. Recital 26 says that GDPR does not apply to anonymous data. Anonymous data means data that's where the case is that data subject is not or is no longer identifiable, including by the party holding the data. So previous guidance published by Article 29 Working Party says that's a very high standard, and the process and approaches to anonymization are very technical, they're lengthy, and they're beyond the scope of this presentation. We're not going to get into the different ways that you can anonymize data and the risks and potential and frequent sort of failures when controllers try to anonymize data. But there is guidance by the Article 29 Working Party out there if you're interested in that. I think it's from 2014. I do want to note that there is a difference between anonymous data and pseudonymous data. The difference is that with anonymous data, you can't identify, either you could never identify the data subject, or at this point, because certain actions have occurred, the data has been stripped, or some other action has been taken, you can't identify the data. There's not another factor that you can combine with it, nothing else that can be done to track that data back to the data subject. But pseudonymous data is data that's been de-identified. It's been, pieces of data have been disconnected from each other that allow, for example, the use of that is you could potentially use certain aspects of data for purposes that you didn't obtain consent if you de-identified it, if you made it pseudonymous. GDPR does apply to pseudonymous data, and so we just want to be careful about saying, well, this data has been sort of de-identified, therefore it's not personal data, and GDPR doesn't apply to this data subject or this data set. That wouldn't be the case. So to be technically correct, you have to have identifiable data for it to be personal data. But based on what Article 29 Working Party is saying, it's likely that many organizations have thought they have created anonymous data when they've probably just de-identified it. So something to consider if you're actively trying to anonymize data, or if and you want to approach those technical methods and see if you can comply, or if maybe attempts at anonymizing data might need to be reconsidered and just move to a de-identified category. So to wrap up today's presentation, see if we can have a few minutes for questions. Why are we talking about personal data? The consequences are significant. There is significant confusion, and there are challenges no matter what interpretation you take. So from my perspective, this is a subject, while detailed and technical and probably not very interesting to many people, that's worth evaluating and making a decision on. Who are we talking about and what data are we talking about? Your organization should identify the potential pool of data subjects that you might process data for, as well as both the logical and legal elements of personal data. And then document your organization's decision in a way that's understandable by the entirety of your organization, so that you can properly think through and implement policies related to breach and data rights, records of processing, and consent. And then review and update your organization's decision-making regarding your potential pool of data subjects and the personal data elements based on new products that your organization creates or delivers, new services, or new ways of processing existing products or services. So that process of decision-making is going to be an ongoing one. And then what do you do after all of that? My recommendation is to retain competent legal counsel to help you through what constitutes a data subject and what constitutes personal data. I expect for us to get clarification in the form of either guidance or enforcement activity, and you want someone supporting your efforts to make a good decision on that. And then make a defensible business decision around what constitutes a data subject and what constitutes data elements. And I think organizations generally know when they're making a decision that's defensible versus one that's very risky and not defensible. And then finally, make the applications from these concepts specific to your organization. If you're processing EU data subjects and you're physically located outside of the EU, then the challenge is different to you than if you're located within the EU. If you're dealing with circumstances where you regularly don't know or have difficulty knowing if the data subject has potential connections to the EU, then you want to think through how you're going to handle those circumstances in particular. You want to think through what data elements does your organization particularly get, those contextualized data situations where you could combine data with the current technology to identify a certain data subject, and perhaps you have certain data elements that you aren't sure if they're actually personal data. And then think through the risk. Where are you most likely to experience a data subject complaint or inquiry? Where are you most likely to experience the threat of unauthorized access or disclosure? And where are you most likely to experience the visibility to supervisory authorities? Those are the places where you should prioritize your time and your resources when you're thinking through who is a data subject and what kind of data are we talking about. Thank you for your time. That concludes our presentation. We're going to continue to produce GDPR content through various channels throughout the year, and we'll provide notifications when that content is published. Now, I think we have just a few minutes for questions if we have any.
Yes, we have a ton. The first question a lot of people ask is about dual citizenship between an EU and non-EU member states. Will that apply to GDPR?
I think if someone is an EU citizen, then the first part of the consideration is yes. I don't think the dual citizenship sort of negates that coverage. You'd still need to think through, does it matter where their data, where they are, where their behavior is located when you're processing it. So if a dual citizen is from France and another country is located in Australia and they give personal data, that's still a question to be addressed, but I don't think dual citizenship removes the applicability of GDPR.
Another question that several asked is, who is the supervisory authority going to be in the U.S. or other non-EU states?
So for the U.S., I would treat the Federal Trade Commission as the comparable to a supervisory authority. It's the federal entity that's responsible for enforcing and overseeing the Privacy Shield, as well as other sort of data protection and consumer protection laws. So it would be the FTC. And then across the rest of the world, some countries may not have something comparable, and others may have something similar to an organization that oversees either consumer protection or information security. Those would be the ways to look for what would be comparable to a supervisory authority.
And on that note, Mark, could you just give an overview of kind of what the fines could be for noncompliance?
The signs for, do you have a chance to clarify that?
The fines with an F, not the sign.
Oh, fines for noncompliance, sorry.
Yeah.
Yeah, they could be up to, there's sort of two tiers. One tier is 10 million euros and the next tier is 20 million euros. So, or a percentage of global revenue, depending on which one is greater. So those are the potential fines for noncompliance.
Another question that several people asked about is kind of study abroad students, EU students coming to a non-EU state or vice versa. How would that apply to GDPR?
That's a great question. So that gets into sort of the connection to the EU, residency or citizenship, and location. I think the answer is unclear and makes it difficult. The conservative approach would be, the most conservative approach would just say, we're going to treat a case where it's, for example, a U.S. student studying abroad in the EU, we're going to treat their data as subject to GDPR. And I think there's a case to be made on that, just on the fact that the language of GDPR says that entities located in the EU are subject to GDPR. So I think there's a good case to be made there. But the situation where an EU citizen or resident is studying elsewhere, I think it could go either way, that their data may not be subject to GDPR because their behavior is not in the union, they're not physically located in the union. But it may be a case where just practically the EU wants to enforce that, or a supervisory authority wants to enforce that. So again, conservative approach would be anybody that you have an awareness of with a connection to the EU gets covered by GDPR.
I think a lot of people are hearing about kind of opt-in and opt-out on websites now in terms of GDPR. So if you have an opt-in or opt-out process, does that reduce liability?
It's an aspect of compliance, but it doesn't necessarily, I'm not sure if it reduces liability. It's, you can't have, for example, I think what most people are going to deal with or have heard about is you can't have, if you have a box that says, that's already checked, that says I agree to the terms and conditions or I agree to the privacy policy, and the user is just required to click a button, that's no longer acceptable. If you were to have a box, it needed to be unchecked, and the user would have to affirmatively check that box in order to demonstrate consent.
How do you identify, if someone is a resident or an EU citizen?
So I have to confess, my background my legal background is not in immigration law, so I am less familiar with aspects of EU citizenship and residency, and neither GDPR, the law itself, nor guidance has provided us with any sort of parameters to consider. But one way to do it is just simply to take a data subject's position at face value. If they communicate that they are a resident or a citizen of the EU, then that's one way to do it. If they show you sort of identification such as a passport or other identification that could indicate that they're a citizen or a resident of a state, that would be another way to consider it. And then the most broad-reaching and the situation that most organizations are dealing with is an IP address. And that doesn't tell you citizenship or residency, it just potentially tells you location. It could be a non-EU resident or citizen located in the EU or somehow otherwise indicating from IP address that they're in the EU. And some organizations are just saying if the IP address indicates that it's from the EU, we're going to treat it as if it's subject to GDPR.
Are payment tokens considered information that can be used to identify a natural person?
I guess that would depend on the information included with the payment token. That would go to that sort of contextual consideration. You know, is that information by itself useful, or does it have to be combined with other data to identify the person? And then that finally, the reasonable likelihood that someone could use it to identify someone. Would it take specific technology, time, cost, or is it relatively easy, free, and accessible to identify them? So I'm not overly familiar with all the information potentially contained in a payment token to be able to state more definitively whether or not that would be personal data.
We will wrap it up with one more question. Does a U.S. company have to register with the Information Commissioner's Office?
So GDPR requires the designation of a representative in the EU if you don't have sort of like an office or a physical presence in the EU for certain organizations based on certain criteria. In my experience, that criteria is almost always met. And so you would have to establish a designated representative in the EU and then provide that contact information with supervisory authority. If for example, that your lead supervisory authority or your office was located in the UK, then you would have to communicate that information with the ICO.
Gotcha. This is just a topic I think we'll probably cover in the future. Someone asked how Brexit applies to GDPR, and I know that's probably a huge answer, Mark. But I wanted everyone to know that we're thinking about that, and we'll hopefully answer that in the future.
Yeah, that's definitely a topic that's worth consideration.
That's more than a 1-minute answer.
Yep.
We're going to wrap it up for today. Thank you so much for joining us. And like Mark said, we will continue to do GDPR content throughout the year. If you missed our first 2 GDPR webinars in this series, they are available online. You can easily find them on our website, and I'll have a link to those in your inbox tomorrow as well. Everyone have a great day.